Good afternoon, Council President Fanny Gonzalez, Vice President Balcom, Council members, of the community. My name is Esther Wells. I'm an immigrant and a lifelong resident of Montgomery County, and I'm here in strong opposition to Bill 18-26, the Continued Excellence in Public Service Act. This bill raises important questions about how the county approaches police hiring, particularly with respect to serious legal risk, unnecessary financial burdens on taxpayers, and operational effectiveness. The stated goal of this bill is to identify applicants who have intentionally violated constitutional rights. However, as drafted, the affidavit requirement raises an important concern. It may itself introduce constitutional risk, particularly related to the compelled self-attestation and due process. In attempting to protect constitutional rights, the county risks adopting a policy that could be challenged on those same constitutional grounds. That is something this council should carefully consider before moving forward. More broadly, the likelihood of litigation is moderate to high. Montgomery County has previously faced challenges where local policies were narrowed or invalidated due to conflicts with state authority or constitutional concerns. This bill raises similar concerns, including potential state preemption issues, constitutional vulnerabilities, and possible conflicts related to federal authority. If this law is challenged, and there's a strong chance it will be, taxpayers will pay the price. That includes years of legal defense costs, potential settlements, and attorney fees, all while the law may remain in effect but legally uncertain. That is not fiscally responsible policymaking. When organizations are facing operational and financial strain, it is important to avoid layering on requirements that may deepen those challenges rather than resolve them. Implementation requires additional staffing, expanded background investigations, or increased reliance on overtime. Accountability should be based on neutral, conduct-based standards. Research suggests that indicators such as written reprimands, suspensions, unjustified use of force, and substantiated bias claims are more reliable predictors of future misconduct than a narrowly framed affidavit tied to a specific date and policy issue. Currently, MCPD is legally required to review an applicant's misconduct history from any prior law enforcement role. That approach is objective, legally sound, and aligned with public safety. Bill 18-26 offers a solution in search of a problem. It risks creating the perception of ideological screening rather than a fair and professional hiring process. That undermines confidence both within the department and the community. We also cannot ignore operational reality. MCPD is already facing staffing shortages and increased response time. This bill adds complexity, delays in hiring, and may discourage experienced candidates from applying, all while increasing administrative costs. For these reasons, I respectfully urge the council to vote no on Bill 18-26. Regarding expedited bill 23-26, while this bill correctly aligns Montgomery County with state standards after the Maryland Supreme Court invalidated the prior 2022 law, we must address the process that brought us here. The original unconstitutional bill 21-22E was co-sponsored by then Council Vice President Glass alongside Council members Gerando, Friedson, Hucker, Navarro, Reamer, Katz, and Rice. Because that unlawful bill stood for nearly 4 years before the Supreme Court struck it down, the constitutional rights of law-abiding residents were actively violated for 4 years. This demands immediate systemic accountability and financial transparency. First, what is the standard operating procedure for reviewing council bills? Council attorneys draft them, and then the county attorney's office reviews them. If this review process is functional, how did an unconstitutional preempted bill get passed? What specific remediations will be made to your legislative procedures to minimize the future erosion of our rights? Second, we demand absolute financial accountability for this failure. How much taxpayer money was wasted litigating Bill 21-22E all the way to the Maryland Supreme Court over the last 4 years? What is the exact cost of this failure to Montgomery County taxpayers? How many adverse court cases, administrative burdens, and ongoing financial liabilities have resulted from righting this wrong? Over the last 5 years, what is this council's exact track record and percentage of dissenting court opinions? There is no problem our elected officials need to solve that requires violating our constitutional rights. If you cannot govern within constitutional boundaries, we need new leadership. Taxpayers deserve immediate transparency. Where can residents find a county council legal fees report similar to the model used by MCPS? See Exhibit C. We deserve a report detailing all outside counsel expenditures. Stop wasting our money to restrict our freedoms. Pass Bill 23-26, fix your unconstitutional review process, and open your legal books to the public to show taxpayers exactly what your legal errors are costing us. Thank you.
5 minutes. Very good. Thank you for being here. This public hearing is now